no ambiguity. They pronounce upon the rights of the deceased and entitle the applicants to bring this application. Exhibits D and D1 to D6 were also unchallenged and therefore must be taken by the court as genuine and a true representation of the content as stated on the face of this document. In light of the orders made on pages 36 and 37 of Exhibit C, I answered the 3 questions formulated for the cost determination as follows. Now, the deceased, Mr. Sargwa Loham Bwaji, was in the service of the defendants until his demise and thus entitled to all the privileges, benefits, entitlements accrued to any civil servant in the service of the first defendant. 2. The deceased, Mr. Sargwa Loham Bwaji, was entitled to all the salaries, benefits, and entitlements as permanent secretary in the service of the first defendant and or the fourth defendant from the 14th day of May 2007 until his demise on the 22nd day of December 2016. And finally, the deceased, Mr. Sargwa Loham Bwaji, who died as a civil servant / permanent secretary while still in the service of first and or fourth defendant, was entitled to the salaries and allowance as the pioneer MD/CEO of the Plateau State Fertilizer and Chemical Company Limited, and the claimants as the valid administrators of the estate of the late Mr. Sargwa Loham Bwaji are entitled to be paid same. In view of the foregoing, I therefore grant leaves 1, 2, 3, 4, 5, and 6 as prayed by the applicant in consideration of the blatant disregard of the orders of the court by the respondents. This court is must and is inclined to award exemplary damages against the defendant. In granting relief 8, I hereby award the sum of 2 million naira against the respondents jointly, which is to be paid within 3 months of today. I must, however, refuse prayer 7 for costs which has not been proven or justified being couched as special damages. The alternative prayer 9 must also be refused, as the law is that it is only when the claim for the substantive relief cannot succeed will the court consider and grant the alternative relief. See New Breed Organization Limited versus Eromose. In other words, it's only when the main reliefs fail that the court is at liberty to consider the alternative claim and award same if proved. See Nwoji Komeni was Ochi citation also provided, and ruling is hereby entered accordingly.
Oh Lord, we are most grateful. Thank you for.
Baron,
Yes, my Lord.
Baron,
Yes, my Lord.
you may be grateful, but I have a problem with the way you couch your questions before the court.
All right.
Let me ask you this question.
Yes, my Lord.
Ashak is, I believe Mr. Ashak is listening as well.
I am, my Lord.
Now, just listen carefully to the way you couch the question, Mr. Maran. Whether by the holding of the court in the judgment of the High Court of Justice in Plateau State in suit number PLD/J347/07 and delivered on the 21st of October 2009, Exhibit C, the late Mr. Sargwa Loham Bwaji until his unfortunate demise on the 22nd day of December 2016 was not in the service of the first defendant under the superintendence of the fourth defendant and thus entitled to all the privileges, benefits, and entitlements accrued to any civil service in the service of the defendant. Now, how do you answer that question, Mr. Maran? Do you answer in the negative or do you answer in the affirmative? You say whether by it he is not entitled. Do you understand? Is Mr. Maran still there or he has left us? Mr. Dajak?
My Lord, I'm with you.
Do you understand what the court is trying to say here?
I understand, my Lord.
What is the problem here?
The problem is that the question itself carries a dual response that it expects.
If you answer in the affirmative is wrong. If you answer in the negative is wrong.
Is wrong, yes, my Lord.
Because looking at it this way, if you say whether or not he is not entitled,
yes.
That word not created the problem.
Negates, yes, my Lord, it negates the earlier premises.
So you cannot say, well, whether by the decision he is entitled to this. It is by that decision he's entitled to it, but when you say whether he
or
is
not,
when you say whether he is not entitled to it,
yes,
I mean,
it negates the answer that is to be expected. I understand what
you cannot simply say in the negative or in the affirmative. So that's why I have to answer the question specifically so that it will be clear what the court is saying.
I understand, my Lord.
You will have a copy of the decision by Thursday. I'll be in Jos by then.
All right, we're most grateful, my lord.
Thank you, gentlemen.
Yes, my lord.
Now, do you have counsel for Oculus Pharmacare, Mr. Ada Kanyip McLewis?
Yes, my lord. Yes, my lord.
All right. The court decision is ready, and I'll proceed.
As the court pleases, my lord.
Now, by notice of preliminary objection filed on the 2nd of November 2022, defendant seeks the following orders: and 1, an order dismissing the claimant's claim for lack of jurisdiction, and 2, for any such further order or orders the court may deem fit to make in the circumstances. The application was predicated on the grounds that 1, the court has no jurisdiction to hear and determine this suit as the claimant's suit borders on the recovery of money from the defendant. The jurisdiction conferred on the National Industrial Court does not extend to recovery of money. The subject matter of this suit has no connection with the strict master-servant relationship and the conditions of service. And 2, the suit is incompetent because the seal affixed by counsel to the claimant had expired, which it must be deemed that there is no seal on the processes filed before the court. This application was supported by an affidavit of 8 paragraphs and a written address, and responding, the claimant filed a counter affidavit on 9/1/2023 alongside a written address. The defendant then filed a reply on points of law on 27/1/2023, albeit out of time. The applicant failed to file an application to regularize this process, nor did the applicant pay the prescribed fees. The court would therefore discountenance the reply on points of law filed on 27th of January 2023. Now, this is the court's decision. Summarize your arguments all. Now, having considered the arguments of counsel and the process, I must immediately point out that the learned defendant counsel cited no authority that expressly stated that the subject matter of this suit does not fall within the jurisdiction of this court. Counsel simply gave its opinion and expected the court to dismiss this suit without more. This is not how advocacy works. Courts do not render decisions based on the simple opinions of counsel. Now, the applicant contests that the subject matter of this suit is outside the jurisdiction of this court. And I'll ask the question here. In the absence of an employment relationship between the parties here, would the subject matter of this suit have arisen? The answer is most certainly no. The court cannot go into the merits of the relief sought here by the claimant in this suit, but it is my considered opinion that the subject matter of this suit falls squarely within the definition of the matters, quote, connected with and incidental to any employment matter, end quote, as envisaged by Section 254CA of the 1999 Constitution of the Federal Republic of Nigeria and as a whole. I therefore find no merit in the grounds of this objection, and I is hereby overruled. Coming to the second leg of objection, I refer to the binding decision of Emechebe versus Seto Nigeria Limited, citation provided, which is on all fours and consequently applicable here. His Lordship Abubakar JCA filed as follows, and I quote his Lordship. Considering the issue of the stamp and seal and the validity of the origination process goes to the root of the case, because if the origination process are found to be invalid, then there would have been nothing to activate the jurisdiction of the lower court, and consequently, the proceedings and whatever decision is reached would amount to nullity. Jurisdiction is a threshold issue of substantial significance, and the moment the issue comes up in any proceedings before the court, it is proper to resolve it first before taking any further step. So doing will obviate the necessity to invest too much in doing an exercise in futility if it turns out the court lacks jurisdiction. See Idigbe versus Omokafe, citation provided. The contention of the appellant is that the Nigerian Bar Association stamp and seal affixed to the origination process by a respondent counsel at the lower court had expired, and therefore the process should be deemed irregular, and that no application had been filed to regularize the said defective processes. The respondent, on the other hand, argued that the failure to use seal does not nullify the court processes, and that in the instant case, there was in existence valid seal of learned counsel, and that the respondent filed an application to regularize the process before the court. In my view, the purpose of the Nigerian Bar Association stamp and seal is to ensure that the legal practitioners who file processes in court have their names on the roll of legal practitioners in Nigeria, and that quacks, imposters, and meddlesome interlopers do not infiltrate the legal profession and present themselves to litigants as legal practitioners. As I recently stated in Rosolo vs. FRN unreported appeal number CA/L/271/2023, 2013 rather, I beg your pardon, page 16, delivered on 27th of February 2017, the requirement and purpose of Rule 10.1 of the Rules of Professional Conduct for Legal Practitioners, 2007, is that the legal practitioner who signed the legal process must affix his stamp and seal. The rationale behind this requirement, in my view, is to checkmate quacks in the legal profession and to ensure that the legal process are filed by genuine legal practitioners who are registered members of the Nigerian Bar Association and are truly qualified to practice law. To hold as the learned counsel for the applicant strenuously urged us would amount to enthroning technicalities over substantial justice. No matter how ornamental, fancy, and high-sounding submissions of counsel may appear to be, we must elevate substantial justice over and above technicalities. It is a matter of duty of the court to do so. See today's Car Limited versus Lasako Assurance, citation provided. The originating processes were duly signed and stamped by learned counsel for the respondent, and the stamp of the legal practitioner are fixed even though expired. In my view, there is no sufficient basis to strike out these said processes. So doing, in my view, would amount to pushing technicalities too far. In Nason versus Peterside and other citation provided, the Supreme Court considered the failure to affix the MBA stamp and seal on the originating petition and held as follows. With regard to the lack of MBA stamp and seal on the petition, I refer to the recent decision of this court in General Bello Sarki Yaki versus Senator Abubakar Atiku by Gudu in SC 722/2015, delivered on 13/11/2015, when this court held that the failure to affix the approved stamp and seal of the MBA process does not render the process null and void. It is an irregularity that can be cured by an application for extension of time and a redeeming order. In the instance case, since the respondent's origination processes contain a stamp which bears the name and number of the counsel who filed the said processes, and it's not that the respondent had failed to affix any stamp at all, and even if the appellant's contention is held herein, it is at best an irregularity, which can be remedied by affixing the unexpired stamp and seal, which from the records before us, the learned counsel for respondent no doubt has, having been clearly affixed to other application filed at the lower court. Since the material constitutes part of the record before us, I am now bound to take judicial notice and hold that the submission of learned counsel for the appellant on this point lacks merit and must be and is hereby discountenanced by me. See end quote. I also cited the case of CB and as a citation provided. I find the dictum above applies here, and this suit is not incompetent by reason of the claimant respondent counsel affixing an expired stamp. I therefore overrule this leg of the objection as well. On the whole, I dismiss this preliminary objection and award cost of 50,000 naira in favor of the claimant respondent to be paid by defendant within 7 days of today. Court ruling is entered accordingly.
As the court pleases, we are grateful, my lord.
Thank you.
So in circumstances, my lord, we'll be asking for a date for hearing to prove our case, my lord.
Liaise with the registrar. You can meet with the registrar today. You can have a date as early as Friday. Because I've given the registrar the dates I'll be sitting in Lagos and when I'll be sitting in Jos. So the registrar knows best. I don't have the diary here with me, so let me not mislead you.
We're grateful, my lord.
Thank you, General. What about Peter Aren and Plateau State College of Health Technology and 5 others?
Yes, sir, we're here, sir.
We have counsel?
Yes, sir, we have counsel for Peter Aren, and Peter Aren himself has joined us in the Zoom meeting, in the Zoom ruling, sir.
All right. And for the defendants?
Well, for the defendants, so far, the ministry is supposed to be the Ministry of Justice.
All right. Now, by an application, this is the court's decision. By an application filed on the 30th of November 2022, the applicant here seeks the following orders. 1, an order setting aside the suspension of the claimant as staff of the Administrative Department of the Plateau State College of Health Technology, Zawan. 2, an order setting aside the discontinuance of the payment of salaries of the claimant applicant. 3, an order mandating the first defendant respondent to pay the salaries of the claimant for the months of June, July, August, September, October, November until this order is complied with. 4, an order of interlocutory injunction restraining the first to 6 defendants and respondents gently and severally by themselves, their members, agents, previous, and assigned and any other person acting through them or however from taking any further steps during the pendency of this suit in any shape or form, including but not limited to inviting the claimant applicant to answer any query or taking any disciplinary action on the issue before the court pending the determination of the substantive suit. The application was predicated on 17 grounds stated on the face of the motion paper and supported by an affidavit of 21 paragraphs and a written address. In response, the defendants filed an 8-paragraph counter affidavit alongside a written address. Claimant applicant then filed a further affidavit on the 13th of December 2022 alongside a written address. Now, having considered all the processes and the amendments in the various affidavits as well as submissions of counsel in their respective addresses, in this court's opinion, there are 2 issues here. I've carefully looked at the relief sought in this application, and it is my considered opinion that they form a course of action where the parties can ventilate their grievances, as these issues cannot be resolved by way of a motion. As such, I'm wary of making any pronouncements on the merits or otherwise of the prayers sought here. The second issue is whether or not the court can pronounce upon the prayers here without touching on the relief sought in the substantive suit. I do not think so. I'm therefore constrained not to delve into the substantive matter where all the evidence has not been placed before the court for a proper determination. I therefore strike out this application and order the matter to proceed to the hearing of the substantive suit. Rule is entered accordingly.
As the court pleases. But most of that, sir.
Yeah, let me explain my thoughts that will probably make this ruling clearer for you, counsel. Right?
Yes, sir.
I believe you have a course of action.
Yes, sir.
Not just something that can be resolved by an application, right?
Yes, sir. Yes, sir.
The only issue you have here is that this course of action must have arisen during the pendency of this suit.
Yes, sir.
Right? But that
Yes,
does
sir.
not stop you from, my own opinion, does not stop you from bringing another action. Because you have to look at when all the facts, right?
Yes, sir.
That give rise to the course of action are complete, right? You're talking about, just go have a look at it. That is my own opinion. I believe you have another course of action. That is why I will not pronounce upon the merits here. I will not say anything. Because all right. Thank you, gentlemen.
Thank you very much. Thank you, sir.
I'll see counsel on Thursday.
Okay, sir.
Thank you, gentlemen.
My lord, we again.
Yeah, but we never exited. You did wait first, maybe we come up for this place. Yani? I'm good, man.
So no, I have a matter before him tomorrow. I wanted to find out.
Me?
No, before his lordship.
Okay.
So it's okay. Take care then.
John, take care, brother.
Enjoy yourself. Bye.
Mr. Aren, we'll talk later. Just call over the phone.